we did spend a lot of time kind of framing out the role and purpose of pretrial, kind of where we can improve on in the future. And so now I think it would be kind of good to kind of talk about the comparisons to the VPRAI and the PSA to give folks an opportunity to kind of understand the differences, what they're measuring and how they measure pretrial risk. So Wes, do you want to kind of take us through the VPRAI? I know a lot of folks out there kind of know the VPRAI, but just, kind of a refresher of the risk factors and
yeah, sure. So as you can see, there are 8 risk factors that are measured in the VPRAI, and those risk factors can be weighted differently. As you can see, there's one that is given 3 points, some are given 2, and others are given 1. And those are weighted based off of the measures that have, research has been found which of those would be more indicative and heavily weighted towards the overall risk total that is calculated based on these 8 risk factors. Now, it's also key to understand that what it is that this is measuring for, and for the VPRAI, it is any pretrial failure, meaning any failure to appear or new criminal arrest during the time of pretrial supervision or in the pretrial phase. So it is not a bifurcated score in any sort of way. It is a cumulative score that is measured based off of whether these 8 risk factors are present or not. And so the person could get a total of 14 points if all of those risk factors were present. And based off of the points that someone gets, that then calculates their overall risk level. And so as you can see, the lower the risk score, the lower the risk level. The higher the risk total, and however many more risk factors are present for that individual, the more that are present, the higher the overall risk level that individual would be assessed to. And as you can see, those risk levels, there is a percentage of pretrial risk failure that is calculated based off of each risk level. So in a nutshell, that's what VPRAI is measuring. That's how those scores are totaled and what those scores mean based off of how they fall in to a risk level, risk mitigation strategy.
And so Nick, can you walk us through the risk factors, and maybe we can highlight what's different in terms of the risk factors for the PSA and how it measures and approaches the identification of risk for the pretrial stage?
Sure. So the PSA, or the public safety assessment, really looks at 2 individual scores, creates 2 individual scores, and then also has what's called a flag, or just an opportunity to flag individuals that have a higher likelihood of committing a violent crime while released. So the factors, so you'll see how the factors are on the right. There are 9 factors, and you'll notice that some of the factors are only measured in, or only taken into consideration in, one of the risk factors or one of the scores. Some of them are in 2, some of them are in all 3. So you have age of current arrest, so pretty simple. It's the age that the person is arrested at the given time. Current violent offense. This is something that does, and I hate to get into the weeds maybe already, but I will start that right off the bat. Current violent offense requires that jurisdictions actually classify what is a violent offense and what isn't. And Arnold Ventures does provide some direction on what they consider large categories of violent offense.
And to pause you real quick on there, Nick, that is one thing, we have not done in terms of working with stakeholders. So from a state perspective, we defined risk, and it was actually done from a researcher perspective, and so that's what's been adopted. And we do have the Code of Virginia as a guide, but some of it is outside of that. So it sounds like with the PSA approach, the stakeholders look closely at defining that. Am I understanding that correctly?
Yeah, so this is different. So it's different again from jurisdiction and state to state. So the state of Wisconsin does not have a all-encompassing violent offense list. We do have a code that does identify violent offenses, but it's actually narrower than what the PSA considers violent offense for the research and the validation of their tool. So you're going to have to do, I shouldn't say you have to, you're going to at least have to compare and make sure that you're comparing apples to apples. But it may mean that if your statute already identifies violent offenses, that you may have to either add some that aren't traditionally right now included, or you may have to remove some that are traditionally included into that violent offense category based on the definition. And again, this is a very, very, very nuanced conversation, but at a 3,000 foot view, Arnold Ventures, the sort of this terminology they use, if it's not rape, robbery, murder, assault, it's probably not a violent offense. But again, that encompasses a large range of behavior, and it's a lot more nuanced than what I just said.
Okay. Yeah, thank you.
Pending charges at time of arrest is another factor. Again, pretty simple. Prior misdemeanor convictions versus prior felony convictions. So you can see that we're not just looking at convictions in general, that we're actually splitting out misdemeanor convictions versus felony convictions. So as you can see, misdemeanor convictions is included and helps calculate all three scores, whereas prior felony conviction is only considered in new criminal activity. Again, prior convictions, 5A, prior convictions, a misdemeanor or felony, again, included in new criminal activity. Prior violent convictions, again, where the violent offense code comes up again. So you see where it's not just used in one circumstance when you're taking a look at scoring, you're taking a look at violence offense twice, one for conviction and one for current offense. And then 7 and 8 are your sort of traditional FTA measures. As you can tell, the research has shown, for whatever reason, but the Arnold Ventures highlighted that a 2-year cutoff. So failures to appear that occurred in the past 2 years are weighted a little bit higher than failure to appears that occurred longer than 2 years ago. And again, you can see FTA, ironically, I shouldn't say ironically, but maybe surprisingly, it was surprising to me that FTA within the past 2 years not only is an indicator of failure to appear, but also an indicator for new criminal activity. And then finally, prior sentence to incarceration, and I won't get into all this is again a very nuanced conversation, but it's whether someone has been incarcerated purposely as part of a sentence for a significant period of time. So again, those definitions will be fleshed out if you continue to pursue the PSA and further. The great thing about these risk factors that I really give Arnold Ventures and the trainers on the PSA a lot of credit for is there is a manual that highlights each and every one of these so that there's no confusion. The idea is, because you're looking at, and this is a big difference from the VPRAI and the PSA, is because you're looking at static factors. There's not a question about whether someone was employed or not, right? This is, where are they now? There's no dynamic where they can go from unemployed to employed and you start questioning the risk assessment. This is solely based on static factors. They want to make sure that the manuals and the definitions are as clear as possible. Now, the other thing that poses some of this challenges is that, again, state to state, statute to statute is not always obviously equivalent. So there has to be a lot of conversations about what counts for what. The other big change that I would put in here, that at least was a big change for us, is when we're looking at convictions and when we're looking at criminal history, we're not just looking at state criminal history, we're looking at nationwide criminal history. So you have to have access to NCIC records to run this, which can pose some challenges, especially when you're interpreting other states' statutes and crimes. But they are working on I don't think it's been released yet, but it hopefully will be released as part of the APPR project, is basically a comparison, a software compendium that'll allow you to take a look at statutes and compare what does battery mean in Virginia versus what does battery mean in Wisconsin or Illinois or Michigan. So that'll be hopefully coming out in the next, I would say, 2 or 3 months at the latest. That should be able to help jurisdictions sort of talk about those offense charges.
So Wes, looking at this, excuse me, real quick, what do you talk to us about some of the differences you see? I think some of these are, things that we currently look at in some fashion or another. Yeah. And yeah, go ahead with that one. I have one more follow-up question.
No, that's okay. So some of the risk factors of the PSA, for those of you in Virginia who are familiar with our database system that we utilize when we key in and calculate you'll notice that some of the risk factors are actually what we are now logging and researching as research factors. And so we're looking at this information and capturing this information and data now, and obviously trying to examine what that means for Virginia and our current cases that we come in contact with. There are definitely some similarities in there. There are some that we do not measure. I guess for one that sticks out to me, I don't recall that currently we measure how old someone was at the age that they first were as a risk factor, as well as how many years ago the FTAs were. There are the risk factor in Virginia is whether or not there are 2 more FTAs, not necessarily of how old or new those FTAs are, which obviously that is a risk factor on the PSA, but it is currently captured as a research factor for us in Virginia now. So we are looking into the nuanced differences of what that could mean for someone in their situation right there.
Nick also brought up another interesting point, is that, with a static tool, and one thing that it sounds like Arnold Ventures did a good job with is making sure that the instructions and the training help the scorer clearly understand which each factor, what it means. And it sounds like the process that went through, are ones that are hopefully not arguable once it's implemented. Comparing that to the VPRAI, it does include some dynamic factors in the challenges of training. And I know you are one of the VPRAI trainers, and you're on the training advisory committee also. What are some of the challenges we have with the VPRAI regarding that?
Well, obviously, if a factor is dynamic versus static, then that requires us to find out a little additional information, and somewhat can handcuff us in a sense that we do not have it readily available, and it isn't something so easily measured. And so with the PSA, it would not necessarily require that face-to-face interview and a little bit further, I guess, resource heavy work with that. So it definitely has the opportunity for us to not have to examine those dynamic risk factors, which could potentially create some bias in there, as if there's up for interpretation data that we have to look at as individuals who are calculating those assessments and making those decisions based off of those specific risk factors.
Yeah, so sometimes the interpretation is almost has a subjective feel to it. How do you determine someone meets the definition for employment? It seems kind of clear cut, but there are nuances, and staff struggle with that.
Right.
History of substance abuse.
History of substance abuse. What does it mean to be willfully or gainfully employed? Does employment necessarily mean that someone has to be gainfully employed, meaning that they get a pay stub and that they are paying their state and federal income taxes out of a paycheck, or if they're self-employed? Who makes those decisions, and where does that come into play is not so cut and dry as it might seem on the surface once you really start thinking about what those questions mean.
So Nick, do you want to kind of take us through, this is shows how the PSA looks at scoring failure to appear in the points?
Sure. So I'm going to keep this again at the sort of 3,000 foot view. If Virginia continues to move down the PSA track, you will get hours and hours and hours and hours of training on these factors. So I'm just going to gloss over them, and Ken, unless you have any other specific questions or you want me to highlight anything. So again, these are the factors for specifically failure to appear. Again, I want to highlight the fact that this only is looking at failure to appear, and it's not looking at new criminal activity. So again, from a pretrial practitioner standpoint, and certainly from a manager of resources, when I think of differential supervision, the PSA offers another opportunity for us to not only separate risk, but type of risk, the way I'm going to monitor or try to supervise or provide services to someone who has as high risk of failing to appear and low new criminal activity is going to be different than someone who is low failure to appear and high new criminal activity. So the PSA does offer some of that variation. So I just wanted to make that point while I remembered it, because I'd probably forget it later. So the factors that we're looking at again, so pending charge at time of arrest, again, really simple. It's binary. Either they have pending charges or they don't. Again, this is one of those aspects where there's no subjectivity. Either they or they don't. Again, if they don't have it, it's 0 points. If they do, it's 1. Prior convictions. Again, this is misdemeanor or felony. Doesn't matter whether it's a misdemeanor or felony. If they have any prior convictions, again, no is 0 points. Yes is 1 point. Prior failure to appear in the past 2 years. No is 0 points. This is a little bit more complicated. So if they have 1, they get 2 points. If they have 2 or more, they get 4 points. And then prior failure to appear older than 2 years, it's again, really simple. If they have none, it's 0. If they have any of them, they get 1 point. So you can see, this is the one part where I will grant is not always super clear. And this is the problem for everyone in the pretrial field, is how to measure what an actual willful failure to appear is. And again, Arnold Ventures has done a lot of defining around that. And once you get that definition sort of ingrained, this scoring process is pretty simple in the grand scheme of things. And you can see, as Wes said, doesn't require an interview. If I have access to criminal records, I can sit there and look at this and I can answer all of these questions without sitting face to face with someone. Now, there's some other concerns about not doing an interview, and we won't get into those necessarily now, but certainly something that is very easy to score, very easy to get through relatively quickly, assuming you have access to criminal history.
Okay. And so then the scoring for fair to appear.
Yes. So this is sort of an interesting nuance with the PSA specifically. So this is where I'm going to screw up a future slide because I can't remember if it's 13 points or 15 points, but we'll figure that out later. But as you can see, if you add up those totals, that you have a range between 0 and 7. And if you look at any sort of future documentation, they'll talk about scaled FTA score, which is a range from 1 to 6. This was done largely to make sure that the groupings were consistent with the research on outcomes. And it was also partially done, frankly, to make it just easier to use instead of having one scale that was 7 points and another scale that was a different set of points. So the FTA scale can range from 1 to 6 and once you scale it, but the actual points, if you look at the last screen, you're going to get anywhere from 0 to 7. And this is how it breaks down from actual FTA points to the scaled FTA points. So then now we're looking at new criminal activity, and you can see that there's a lot more complexity to this one. But still, at the same time, it is fairly straightforward when you look at the factors. Age of current arrest. If it's 23 or older, you get 0 points. If you're 22 or younger, you get 2 points. Pretty simple. Pending charge at the time of arrest, again, that's a yes/no statement. No, 0 points. Yes, 3 points. Prior misdemeanor and prior felony conviction, again, same concept. No is 0 points. Yes, it's just 1 point. Prior felony, again, 0 and 1. Prior violent conviction, they separate that out because what they found is that individuals, again, who have more violent convictions are more likely to engage in new criminal activity during the pretrial phase. So there's, again, a little bit more counting in this one. So it's not just a simple yes/no statement. Same thing with prior failure to appear in the past 2 years. And again, I think this was one of the most shocking things for me because I always looked at FTA as only being a factor for failure to appear. The research that the Arnold Ventures went through found that prior failure to appear in the past 2 years also had an impact in predicting new criminal activity. So again, another comment, they just have to count 0 is 0, 1 is 1, 2 is 2 or more. So, and then prior sentence to incarceration, again, simple yes/no question. And again, this is another thing that I want to highlight. If you have access to your criminal history, a full criminal history, you will be able to answer all of these questions without interviewing someone. So again, it's static. So one of the things that can be a critique, and I guess I would say it's static-ish. It's 95, 98% static. The one thing that you will notice that can change from one score to another score is even if they receive no new charges, just as time passes, is the FTA scores. If it all of a sudden moves an FTA from less than 2 years to older than 2 years, that would change someone's score. But other than that, everything is static. This again was 13 points. I thought it was 13 or 15. I knew it was one of those. So again, this is another one of those, just a slide highlighting the difference between the scaled score and the actual, and this is actually should be new criminal activity, not scale total FTA points. Sorry, didn't catch that. So it should be new criminal activity versus new scaled new criminal activity score. Same thing, the actual points can range from 0 to 13. And this just highlights how those actual scores gets transferred over to the scaled scores. So when you're talking about, again, 1 through 6, this is how the breakdown happens. And again, it was done partially to help the grouping, partially helping just making sure that we're talking similar languages and similar scores. It would have been really confusing if someone said, hey, Mike, my defendant scored a 6 on FTA and a 13 on new criminal activity. The idea was to make it easy for stakeholders. A 6 on FTA and a 6 on new criminal activity is the highest risk score, no matter what. You don't have to memorize 2 separate scoring systems for each scale.
And so just make sure people know that was my fault when I copied and pasted the table, so I didn't have to recreate it from scratch. So my apologies.
And no worries, Ken. You had asked me to review them, and I totally missed this. So
no, all good, all good.
And this is your, again, this is actually your violence flag. So again, same things, looking at the same sort of current violent offense, and 20 years and younger, pending charge at time of arrest, prior conviction, misdemeanor, felony, prior conviction of violent conviction. Again, it's all very, very simple to score. You're either getting 0 points because the answer is no, or else you're getting anywhere between 1 and 2 points, depending on. The interesting piece again here that I think is fascinating, again, is the current violent offense and 20 years and younger. So you can see that's actually a measure of sort of two factors that we talked about. One of the things that I do give Arnold Ventures and the PSA a lot of credit for is, and when we talk about sort of the history of risk assessment, I think this is a big evolutionary moment for risk assessment tools. We're starting to look at 2 factors in one. Right. So this is now not only looking at, is the current offense violent, but are you also under the age of 20 years or 20 years or younger? So my hope is as we continue to see the evolution of pretrial risk assessments, we'll probably see more of those factors be intertwined just because it'll increase their predictable power. And again, this is, so you'll notice this is the big difference in the scale. There's not actually there is a scaled score per se, but really the new violent criminal activity is focused on a flag. People that score 4, 5, and 6 on the violent criminal activity scaled score are at what the researchers would say a significantly higher risk of committing a violent offense if they commit an offense while on pretrial release versus those that score 1, 2, and 3. Again, the idea of scaling it is just so that when we talk about scales from the PSA, 1 through 6, a 6 still means the highest, 1 still means the lowest. It's just an idea of trying to make it simpler for stakeholders and practitioners to understand.
So this is another big one that is, you know, really in that next generation of risk assessment. So one of the challenges of a pretrial risk assessment historically has been, you know, what we're measuring, and simply a new arrest is one thing, but a judge who's making a decision is also thinking, well, I mean, it's one thing if a defendant gets a new arrest, but it's another if that new arrest is violent. And
yeah.
So,
well, it's the definition of what does public safety mean, right? And there's generalized public safety, meaning any criminal activity is obviously, you know, in the law, a crime, a state crime, right? But then you have the ability of trying to break down, hey, is this going to be an interpersonal violent crime that we really need to be concerned with? And judges obviously are concerned about it. Prosecutors obviously concerned about that. Is there some concern about the violence flag? Absolutely. this is probably the most controversial thing about the PSA. There are some jurisdictions that have not used it at all. Just said, we're going to capture it for research purposes. We don't feel comfortable using a national data set to apply this violence flag to a local jurisdiction until we have data that proves this. This was actually a surprising outcome when the researchers looked at it. They did not expect to be able to predict this. They said, hey, we have this huge data set, maybe we can, but we're not going to bet on it. And they found this significant difference. So I always caution people to really think about the use of this, because in some jurisdictions, if you apply this violence flag, it just means detention. Okay, they scored a 4 higher, they're being detained, period, end of story. I'm not even gonna worry about it. But again, risk assessment tools are obviously not 100% accurate. You know, if you have a risk assessment tool that's accurate, 70% of the time, that's hugely successful. So we have to understand that even if they receive a 6 on the violence flag, there's going to be a significant chance that an individual is still going to be successful, is not going to be engaged in a violent crime. But it is just highlighting that, this is a concern area. So I think this is one that I struggle with a lot as well, just personally, and I've had a lot of conversations with the folks that have been involved in setting up PSAs all over the country. It's a hard one to swallow because, again, it's still something that violent pretrial misconduct happens at such a low rate and such a low percentage. When we looked at our data in Milwaukee County, it was, I think, under 2%. And that was just because we had 2 cases in a span of 3 months that were sort of complete outliers that wouldn't normally, in a traditional year, it's usually less than 1%. So really hard to I would just say, caution people when you're looking at implementing full implementation, make sure that you have an honest and open conversation about whether you want to do it. My recommendation is always use it as a research factor to start out with. Make sure that you're comfortable with where it's being flagged and when it's being flagged, and then also determine what your response is going to be to it before you implement it widely.
So this is just a sample of the sample or template report, and it actually doesn't fit on one slide, so I've kind of chopped it up into 3. But the first part of it here, so you can see, what the report looks like. Nick, do you want to kind of talk to us about, kind of the approach to the report aspect of it?
Sure, and I will again in an effort to be as transparent as possible. This is a template that none of my jurisdictions use that uses the PSA. They have some really evolving and new software that actually, once you do scoring and once you enter in certain information, it will literally auto-populate this template for you. So there's no manual entry. Because we were sort of they called us a beta tester for the PSA, but it almost felt like we were still in the alpha phase learning about the PSA. We developed our own software system that basically did this. So this is just a sample template that the Arnold Ventures has made available to anyone that implements the PSA. It covers what they consider sort of being the traditional information that's needed for judicial officers when they're making their initial bail decision and conditions determination. So again, pretty simple: name, identification number, arrest date, the report date, case number, current charges, obviously. So this is sort of I look at this as sort of your basic demographic information that you include in almost every report. And then it talks about whether they're eligible for release before first appearance. And that will include the PSA scores, but also they have some ability to start including and incorporating the state statutes, cases that would not be eligible for release. So you'd have that, again, right there on that front page. And then go ahead, Ken.
So Nick, real quick, regarding that part of it, we do have what we call the rebuttable presumption statute, which enumerates circumstances where a defendant is to be denied bail initially, unless the judicial officer overcomes that presumption. So if they don't, we could have situations where they meet that criteria. Is that what we would say, eligible for release before first appearance? Would we say no to that And what is how do we reconcile that?
So I think this is an interesting, and this is part of my, I don't believe that there's a state exactly like Virginia with their system and their statutes. So I think that's a really interesting conversation to have as you're moving forward. If maybe this is a section that needs to be changed, instead of eligible for release, it would be, is this someone that has that rebuttable presumption? And then allows you, again, to sort of add information in that notes sections about what their PSA score is, and then whatever other information that you think the judicial officer would want to know to rebut that presumption of detention. To me, that's an interesting. It's Virginia's system's so interesting because of those complexities. So I think that would be something that I would ask. Again, in the state of Wisconsin, this would be fine, right? As framed.
Okay. Well, I was going to say, and I asked my question before you went on to the next one, but the eligible for detention, technically per statute, anybody could be eligible for detention if the judicial officer determines that there's probable cause that they're,
Right. Yeah. And again, this is where I would argue that the templates, again, are just sort of your starting point to have the conversations. There's some jurisdictions that, in some states, that people aren't eligible for detention based on statutes. They're just going to be automatically released anyways. So I think the key thing here is making sure that the judicial officer is aware of what are the requirements of the statutes, and B, are there any other sort of, is there any other information that the pretrial service agency can offer when they're making a decision, or when they have discretion to make a decision one way or another? If that makes sense.
It does. And it sounds like this is why their implementation process is so collaborative and tailors to state statutes and perhaps practices.
Well, yeah, and again, having, working for a nonprofit that now is going to operate in 2 different states, I mean, I can tell you the complexity of learning not only bail statutes, but criminal code is immense, and it's a heavy lift. I brought up the example of batteries, but those can range across states, meaning completely different activities. So I think this is another one of those circumstances where that in-depth collaborative process, and really it's 2 pieces. I talk a lot about collaboration, Ken, but the other piece I don't talk about a lot, especially when you're trying to get buy-in, and I probably should, is transparency, right? We're all saying that this is what we're agreeing as a pretrial service agency to report on. There's going to be defense bar, there's going to be prosecutors, there's going to be judicial officers and judges and magistrates all at the table. So there's no question of, when they see this, oh, this isn't the pretrial service agency just operating sort of completely independently without any sort of feedback and without any sort of conversations about it. So I think that's a really important piece.
So regarding this template, I mean, and with the context of what Nick just said, Wes, we've obviously struggled with our VPRAI report and, release, detain, and, there's so many layers to this. What do you see our challenges with?
I think you spoke to a lot of it too, with the presumptive statutes and whether or not someone is eligible for release at that first appearance or not. And what excites me a little bit about it is to hear about all of the technical assistance and collaborations that we would have if this were to be the tool we wound up using for the next phase of risk assessment in Virginia, because I think that currently is a big challenge for us in Virginia when we do have risk assessments attached to presumptive offenses, and our risk assessment instrument may be saying this person should be released under these conditions, and yet by statute they are not eligible for release until they meet and exceed that rebuttable presumption. So that creates some conflict potentially between us and the judiciary, as well as even Commonwealth's attorneys and different aspects of the court system. So if that were something that we could kind of package together and tailor it to specifically a Virginia statute issue, to me that sounds pretty exciting.
So the next part of the report looks like it's kind of displaying the score, the output of the score.
Yeah. So Ken, this is actually my favorite section of the report, because this is where it gets away from just reporting the number. I mean, the thing that I love about this template is it really highlights how judicial officials need to contemplate or consider release and detention decisions. So you'll notice in the failure to appear, new criminal activity, new violent activity, it has, well, at least the failure to appear, I'm sorry, in new criminal activity, it has the 1 through 6 like we talked about earlier, and it highlights the number that this individual scored. Great. But the question that I've always received from both judicial officials or public defenders or defense bar or DAs, okay, great, it's a 3. What does that mean? Doesn't mean anything. So this person's a 3-3. Okay, I don't know what that means. So the really great piece is the bar underneath it. Now that says that 3 on the failure to appear score, this person was scored in a group that 81% of the folks that scored in that 3 group in the original data set, 81% of that population made every single court appearance. And only 19% missed 1 or more. They missed something, some court date. Same thing with new criminal activity. Again, it was a 3. 78% in the original data set remained completely arrest-free through the entire process of the pretrial phase, and only 22% were arrested at least once or more, right? One time or more. Same thing with the new criminal activity. Even though they received the flag, look at this, 92% remained violent crime free during the pretrial phase, and only affected 8%, right, of that population. So those are things that, again, when you're talking about and talking to stakeholders, I've really found a huge value to, because again, in pretrial, so oftentimes we're like, oh, they're low risk, or oh, they're moderate risk, or oh, they're high risk. Even those terminologies don't mean anything. This score means everything. And I would tie it to another, future, like, I love how Wes said, in this phase of risk assessment in the state of Virginia, this is what we're moving towards. In the next phase of risk assessment, imagine being able to, instead of using the original data set scores, you can use Virginia specific data set scores because you collected all the outcome data. So now a 3 may not mean 81%. It may mean 85%. It may mean 78%. I don't know. Depends on what your data tells you. But again, when we go back to that local validation, you have the ability, again, to modify these scales to reflect the actual data that you have, if that makes sense. It's really, to me, it's really powerful. This is what all the stakeholders ask for.
Takes away the guessing, and like you said, what does that score of the 3, or what does it mean to be for us average risk, or those sorts of things? Like, what does that mean? And to be able to see, this sort of goes back to the statements in prior Supreme Court cases where admittance to bail inherently involves risk, right? So what does that risk mean, though? And these numbers and this scaling like this clearly shows you that even if someone is middle of the pack on these scales of failure to appear, they're going to come back to court the vast majority of the time. In a political election, man, that'd be more than a landslide, so it's not even a nail biter situation. It is beyond majority. It's the vast majority of people, even if they are middle of the pack average risk for that risk factor, for that type of pretrial failure, they're still likely to come back to court 81% of the time. And 81% success is quite high. So that's something to me that sticks out. That's a vast difference between the way we currently present our VPRAIs to the court and what that tool looks like in presentation form. And I can definitely speak to you that where I've been on the stand in court and have been questioned quite intensely about what in the world does this mean to me as a circuit court judge in our system, felony court, that he spoke through every single risk factor, wanting to know what it meant in open court. How did I get to this? Where did it come from? And how did I get to this person should be detained? And so, that to me is so transparent in nature as to what those two major outcome measures, what that means. And that to me is very beneficial for a judicial officer to have that information.
Yeah, and the other thing I would highlight, and this is again totally selfish as a pretrial practitioner, but we'll talk about it since I think the target audience is largely pretrial directors for this recording, is unfortunately for this template and this sample, they chose a 3-3, which is right in the middle, right? But again, imagine if you had complete control over your supervision strategies. What would be if their failure to appear score was 1 and their new criminal activity was 6? And or vice versa, where you sat there and said, okay, well, now this person has a 6 on FTA and a 1 of new criminal activity. I'm just going to worry about court reminders, and that's it. I'm not going to have them come into our office and do drug testing, put them on GPS bracelets. Forget it. Their highest risk, their likelihood of failing, according to the PSA, is they're going to miss a court date. So I'm going to dedicate all of my resources to make sure that they get to court, and that's it.
Yeah, it would allow us to be pretty creative in how we manage cases and supervise individuals, even within our own current differential supervision framework. That could be tailored specifically, like you say, to these different weighting scales. Having this sort of a bifurcated slash trifurcated score if you throw in the flag there as well. So yeah, you could definitely resource the risk in a very meaningful way.
Well, and again, my MPA, my Master's Degree in Public Administration, is coming out again, is that what it allows me to do on FTA, since we know court reminders are the best at work and they're pretty inexpensive to do, then I'm saving, again, the limited resources I have of staff time to focus on the folks that have a higher risk of new criminal activity. Even though there's not a lot of research about what pretrial supervision does in that area, we can't actually move forward on that research topic until we actually start doing different things with that population. So this gives us an opportunity again to hopefully research what activities under pretrial supervision actually impact new criminal activity as well. But from a dollar and cents standpoint, it's, again, if I have someone that scores a 6 on FTA and again a 1 or 2 on new criminal activity, I'm doing court reminders and telling them I'll see them at their next court date. Take care. And then I'm going to use my limited resources to focus again on the new criminal activity folks.
And I think from Virginia's perspective, one of our challenges is, how do we fully implement differential supervision in a meaningful way? We know when we do it, we're improving our outcomes. But when judicial officers are seeing the risk and without this kind of nuanced way of looking at it as part of potentially the issue, we are getting over-conditioned defendants, and it kind of overrides our response to it and our ability to respond to it, because we have to follow a judicial officer. So I have to think that this would also contribute to better judicial outcomes in context of, learning, you like you pointed out, Nick, 78, and Wes, when you look at the percentages, you kind of quickly see that, well, this person's, the likelihood of any failure, either failure to appear or new arrest, is minimal, and violence is minimal. So I'm not going to over-condition this person. And that's got to help with how we allocate resources and in relation to improving outcomes too.
Yeah, well, and so, okay, this is going to be, again, sort of a sneaky comment, and I don't mean to be sneaky about it, but again, think about when you're having these conversations with your stakeholders, and even before you implement anything, you're creating buy-in for changing how you do supervision in the first place, and hopefully having the conversations with the judicial officers in a way that you say, hey, listen, pretrial is a limited resource at the end of the day. Judge, magistrate, you want to use that resource only when you need to. It's no different than a jail bed day where taxpayers are going to be paying for this limited resource. Let's use it as effectively as we possibly can. And that may mean we're doing a lot of court reminders that don't require a lot of staff time for the folks that are higher on the failure to appear score. And we're spending a lot more time trying to figure out what we can do to mitigate new criminal activity. Judge, isn't that what you want us to do anyways? instead of just ordering us, again, playing golf in the fog. I'm going to order this and I have no idea what the outcome is, what the risk level is. Well, you guys will figure it out down the course. That has to be somewhat attractive to judicial officers, I would think.
No, that's powerful stuff. And so you're making me kind of think through too. One of the things that we did in Virginia with the implementation of the last revised VPRAI and building off of previous research was the development and implementation of a praxis, our release matrix. And what advice do you have for Virginia or any state for that matter, if you're doing a statewide implementation? Are there any best practices around doing that? I mean, is it better to have a uniform, kind of consistent way of doing that across the state? Or, what role do we want to have individual locality input on in terms of developing that?
Yeah, so I think statewide implementation is just a challenge in general, because somehow you're going to try to create a model that works for urban, suburban, and rural areas. And that just is difficult in general, just as what it is. At the same time, obviously having consistency from one jurisdiction to another jurisdiction from a data capture standpoint would be really attractive. The problem also comes down to is the number of resources, and comes down to really how does the state of Virginia allocate resources, not only on the criminal justice side, but also on the social service side. To think that the folks that are coming through the criminal justice system operate in this siloed community and aren't interacting with other services is sort of silly, right? And we've done that historically. So, those are the things that you have to take into consideration. And when you start taking a look at a matrix, I've always been, and this is not necessarily always the most popular, you have to get buy-in from jurisdiction to jurisdiction. I don't know how it is in Virginia, I know how it is in the state of Wisconsin, we have judges that are elected locally. So that judge really is held accountable by their local community. So we've got to get that judge engaged. Same thing with our prosecutors. Our prosecutors are elected locally. Same difference. Even though they're both state employees and required to follow state laws, they are elected locally. So the context is different. You start talking about policing resources and policing practices. And then on top of that, that's just the criminal justice system as a whole. Then you start going, hey, does jurisdiction A and jurisdiction B have the same equivalent funding and staffing for pretrial services? If that's no, then you can't have one consistent matrix across the board, because the resources are fundamentally different, and again, there's all those mitigating factors. Plus, again, I said this earlier, from a sneaky standpoint, you have the ability to create this buy-in locally. So again, I think ideally you'd have one state decision-making framework or release framework. I don't know how realistic that is, short of a state just mandating it. This is what we're doing. But then the concern I have from a pretrial practitioner standpoint is the buy-in. Okay, thanks, state of Virginia, Commonwealth of Virginia. You've now told me to operate this way, and I'm going to get crucified when I go into the court because the judges don't believe in it, the prosecutors don't believe in it, and the defense attorneys don't believe in it. I need some way to figure that out, because we operate, whether we like it or not, we need credibility. And the only way to get that credibility is through collaboration, transparency, and dialogue. And if you can't do that, if it's everything being pushed from the top down, it just makes it really hard. And that's just been my experience. Now, I know Kentucky, on the other hand, has had tremendous amounts of success from the statewide, but then they still deal with local issues. But they have the power, again, centralized at the state, versus, at least from my understanding, in Virginia, the funding comes from the state, but there's a lot of local control.
That's right. So Virginia has kind of a uniqueness. We are not an operational. We don't have a state operational structure. It's a state and local partnership, and through the Community Corrections Act, the Pretrial Services Act, these are local agencies. And so, Wes, I know you work in a unique situation where you're one agency serving two very diverse community types. And maybe that speaks to the challenges as well, even from your perspective, from a single agency, of the approach of one standard way of creating a matrix in a decision-making framework, and the challenges you would have implementing it in two different diverse communities. What are your thoughts on that?
Yeah, the overall risk tolerance between the two types of jurisdictions, both of our offices serve a regional jail. So our Charlottesville, Albemarle, Nelson, they are encompassed in Albemarle, Charlottesville Regional Jail, and the 5 counties, much more rural in setting that our office serves, are served by the Central Virginia Regional Jail. And so the risk tolerance of those localities between the two are vastly different. And yeah, it does create some challenges there when you have a non-localized tool that is driving release decisions and what that release mechanism would look like based off of, say, like our praxis matrix that we do use in Virginia. So you may see very stark differences in the adherence to those by those judicial officers and even potentially through the staff. That it's just, there are definitely nuanced differences and pretty stark differences in approach and general ideology of how they administer justice throughout their community.
Yeah, and can I just want to make one point, because I think this is an important point, is that, listen, I'm not saying that the laws that dictate the vast majority of people should be released should be applied differently from jurisdiction to jurisdiction. That's not what I'm saying. But what I am acknowledging is the fact that what Wes said is that risk tolerance from community to community is different. And I view the pretrial service agencies' roles as educating those stakeholders as to what risk really means. Like, we took a look at, again, in this sample, a 3-3, and all 3 of us agreed this person's not really that risky, right? But my guess is, depending on what this person would be charged with, we'd get different outcomes if we didn't have these risk tools, if we didn't have these conversations at a local level. My guess is we get different results if we went to 5 different jurisdictions, and depending on the judicial officer. So the pretrial service agencies, we talk about educating and informing judicial decision makers. And I historically have always looked at it as very narrow. We're here to educate them or provide information or factual information about this individual defendant. I think the pretrial service agencies have a much broader role, is that our job is to educate and inform judicial officers about the research, about the pretrial bail law, what has been successful in our field before, and certainly about having open and honest conversations about what risk tolerance is, what is the community's risk tolerance. And that's, again, that might be another seminar for some other time. But again, we talk about, it's so easy for us to get trapped into sort of a case processing role, because that's what the criminal justice system is. That's what the system does really well. Really does really a good job at.
Well, real quick, and thank you, Nick, because I think those are some really good points for us to kind of think about, because in the implementation process, as we go through this, it is an education process. It's a learning process. We all kind of have our perspectives of how the judicial process works and how we make decisions. And we talked about risk tolerance, and I think that's, not being a lawyer, so I have to be careful about addressing that. But one of the things that I think I cringe a little bit about when we throw that topic of risk tolerance out is, although it's important as kind of a change readiness kind of criteria, I do wonder, and this gets into the legal system issue. Where does communities' risk tolerance play in applying the law as it relates to pretrial release and detention decisions? And so, if I'm arrested in, a part of a rural part of Virginia that maybe has a low risk tolerance, but I go to an urban area, and their risk tolerance is different. Same set of circumstances, same sort of facts. one would sort of expect I should have similar outcomes, maybe. So I suppose one of those, that's just part of what we're grappling with as we go along this journey. But
So
definitely things.
yeah, so Ken, I think your point is well taken, and I think it's a fundamental issue that every pretrial service agency across the country, no matter what state they're in, has to deal with. And whether it's a state agency or whether it's a local agency, doesn't matter. It's the same issue. The administration of a state criminal code is very different depending on where you're arrested and who's involved. That just is what it is. For this conversation, I think the interesting piece is this is an opportunity to have a dialogue about what it is. And again, the really interesting part is this is not taking out the adversarial process, right? This is not a risk tool that says, hey, just do exactly what our recommendations are and follow it 100% of the time, because then we have a whole nother legal challenge, is that bail's not individualized and the only factors that they can look at are these 9 factors, and there's no mitigating or aggravating factors that the prosecutors can argue, and there's no aggravating or mitigating factors that the defense can argue. Obviously, that's not the system that we're advocating for. So I think, when we talk about risk tolerance, people can also frame that as aggravating or mitigating factors as well. Is that, again, let's take a look at this template, for example. Let's look at FTA. 81% of the time, the people who fit in that box made every single court appearance. There's nothing wrong with the prosecutor saying, hey, I don't think this guy is at 81%. I think this person's the 19%. And here's why. And here are the aggravating factors as to why I think it is. Right? There's no reason for, if it was the inverse, for the defense attorney to say, I know why they're the 19% that they're going to be successful, and there's no score that would be that low. Even the sixes, I think they're 60% successful. So, but there's that aggravating and mitigating factor that the law requires us to have as well. Now, again, Virginia has a complicating factor because of the magistrate system, where that's not always in play at that initial appearance, if I'm not mistaken.
Yep.
So that's something else that we have to take a look at when we're talking about the pretrial justice system as a whole.
So, and just to reinforce the education part of it, we had Joel Bishop, who at the time was from Mesa County, Colorado, come and talk about his experience implementing their decision-making framework. And this was not in relation to the PSA, but the Colorado risk assessment. And he described the process of developing their decision-making framework as kind of a bloody process. It's kind of graphic, but meaning that the stakeholders got in a room and they had some conversations that they probably never had before, and because it involved members of an adversarial system, and people coming from diverse perspectives. The conversations were intense and difficult, but they stayed with it, and the end result was an agreement on how they were going to approach these decision makings. Is that a common thing? I mean, we're sometimes afraid of conflict with stakeholders, and obviously this is not. I think Joel was not being adversarial in his role, but the
Sure.
Stakeholders in their process of development, is that common?
So I can only speak to my experience, because I think that the conversation you brought up is it's almost the closest thing a public system can be to having like an interpersonal or interfamilial argument, right? And my experience was exactly the same as Joel's. When we started talking about some of these decisions, I remember the running joke was, you show up at 8 o'clock, the doors get locked, no one leaves until we come up with consensus, right? And if that means 10 people go in and only 8 people come back, that's fine. We have consensus at the end of the day and we're moving forward. But it also, I think again, it played into people's assumptions about how the criminal justice system should work. It played into conversations about assumptions stakeholders had with other stakeholders. So it was routine for the prosecutors to say, well, judge, this is what you're concerned about. And the judge is going, no, this isn't what I'm concerned about. I'm concerned about something completely different. So it allowed you to filter through some of those preconceived notions about roles and responsibilities, But at the same time, you'd get knockout, drag out fights about, hey, this charge should be on the violence flag, and the defense bar going, there's no way in hell I'm agreeing to this charge being on the considered a violent offense, period. And I'm not leaving. And I don't care if we have this circular conversation for an hour and a half, I'm not leaving until I get my way. But again, those conversations have to happen, because once they happened, when this information was then filtered out, you had a defense bar who could talk to other defense bar about why this decision was made. You had a prosecutor who could talk to other prosecutors about why, this charge was not considered a violent offense. You had a judge who was involved and could train other judges about how scores or how factors are scored. All of those things. And we went down even to having court administration, because again, in my county, local county, we get local county tax dollars to provide pretrial services. So our court administrator was involved heavily. And thankfully she came from a background of pretrial services. And she said, listen, this is how much money we have. This is, we can have a conversation about how to spend it, but you can't spend more than this. That's not how this works. So judge, you can't put everyone on supervision. I'm sorry, that's not feasible from a taxpayer perspective. Judge, you can't put everyone on GPS or drug testing. That's not cost effective. It doesn't produce the outcomes that we want. And again, we can't afford it. All of those conversations were had. And it was I almost call it sort of the bearing of the soul of our criminal justice system, because everyone had to be open and honest and transparent. Otherwise, it wasn't going to be successful. Sorry, that was a long rambling conversation.
You know what? These are important topics. It's hard to rush this. So thank you for indulging me on that. And so the last part of the report just seems to show, the responses to the risk factors. And I guess that gets tailored and customized based on, who's using it.
Yeah, I mean, this is just, again, a transparency section. So this literally just says, hey, this is the factor. This is what the score was based off of this. So if anyone wants to challenge pretrial, hey, you scored age of current arrest wrong, let's go back to the report and see what the score was. That's it. That's really all that page is for.